welcome back to the second section of the symposium. Before we start the panel discussions, how we'll proceed is we will invite the panelists to come up, and then I will introduce you to the moderator. But before we do that, let me invite Alicia Yaman, Professor Alicia Yaman, to say a word about her experience and about Henry Steiner.
Hi, everybody. My name is Alicia Yaman, and I'm a lecturer here and a senior fellow at the P.G. Flom Center. And I'm going to pick up a little bit where Jim left off. I was also an early participant in the human rights program. Before I went to law school, my family's from Argentina. I really engaged in human rights through protest, in those days it was US out of Central America, divesting from apartheid. And when I came here, I found in the human rights program really a language and a structure through which I could channel my convictions and passions into a potential professional career, Jim. But I also found in HRP a family. I am still incredibly in touch with many of the students who were around then, and I was in Barack Obama's class, so it was at the end of the 80s, very early, 1991 we graduated, and I'm still, very close to many of those people in the program. I was just out in Berkeley lecturing in Professor Laurel Fletcher's class on human rights futures. There was a group of classmates who formed a Harvard study group on Iraq in the first Gulf War. That later became the Center for Economic and Social Rights. All of us are still very much in touch. Jason Adkins is here today. So it was really a formative bonding experience. And Henry, of course, was the paterfamilias of that family. And I don't want to be overly nostalgic. It was with all families, there were disputes and contestation and some rebellions. But Henry throughout was, I think everyone would agree with this, played an absolutely anchoring and formative role in our thinking and our dreams for our professional work and the way our professional lives unfolded over the years. Back in those days, it's hard to imagine, but Harvard Law School was not as warm and welcoming as it is today. And it was very rare to be invited to a professor's house for dinner. And Henry would have these annual dinners, which were just exquisite. The food was exquisite, the wine was exquisite, the conversation was amazing. I even remember your wonderful dog, Merlin, at those dinners. And it was a highlight of the year and helped to create this kind of family feeling that we developed. I remember the seminar, taking the seminar with you, Henry, an extraordinary, very small, this was still in the late 80s, very small group of people taking the human rights seminar, and some have gone on to extremely eminent careers, like Tony Angie, who's a Twale theorist. And those seminars were always just so different from other classes because Henry had the ability, with his incredible, unparalleled wit, to probe very carefully, but it was always this kind of, none of us were posturing or trying to pretend that we knew more. It was really this experience of openly questioning, and that was very much encouraged by Henry, and he shared some of his work. I even remember, I may be misremembering, but I think it was during those years that you were working on kind of a piece about how thin the notion of political participation was from the Committee on Civil and Political Rights, and discussing that with us as though we were peers, and he valued our insights and input. And that went on through the writing our papers. I remember being quite intimidated when I had to go for one-on-one sessions with Henry, because I knew that he was going to go right to the weakest point in whatever argument I was making. But I always came away from those sessions feeling, it's not pretentious to say illuminated. Henry didn't give us answers, but he, with almost a yogi's touch, tweaked the way we were looking at things to make us ask deeper, better questions. And I hope over these many years I have been able to continue to do that. It was a time of radical transition in the late 80s, early 90s for the world and the human rights movement. It clearly is, again, today. We're at a deep inflection point that we'll be talking about more through the two panels. But throughout all of that, Henry, you really were just an absolute inspiration and formative figure in so many people's careers, and through your textbook, hundreds, thousands of others around the world. And as was already said, we wouldn't be here without you. Thank you.
Thank you. Now I ask the members of the first panel to take the stage. Our moderator, Professor Tyler Giannini, is a clinical professor of law and the founder and director of the Human Rights Entrepreneurs Clinic at Harvard Law School. Previously, Tyler was co-director of the Human Rights Program and the International Human Rights Clinic. And he was the founding director of Earth Rights International before that. Besides his extensive experience in Myanmar and South Africa, Tyler has been involved in seminal cases including Doe versus Unical, In-Ray South African apartheid litigation, Mamani versus Sanchez, and Kiobel versus Royal Dutch. His areas of interest include human rights litigation, business and human rights and the environment, climate change and human rights, as well as community-centric approaches to human rights practice. With that, I welcome the second panel.
Thank you, Abahir. Is that on? All right, very good. Okay, thanks for the kind words. I just have to first say, before I introduce our incredible panel, how grateful I am to be here in the room with colleagues, old friends, and to say that for me, the Human Rights Program has been a place to not only explore the intellectual questions and the human rights practice that has been touched on today, but to watch so many seeds be planted and grow. And I think we're going to see some of that today with some of the people, but we've already heard it. This is a place of cultivating hope and futures in the wake of battles and fires that we're fighting. And I think that is what I take away from the Human Rights Program, and so grateful to have been a part of it for so many years. So with that, let me introduce who's on the panel today. I'm just going to do short introductions just so you know who is here, and then we're going to go into more extensive introductions as each person presents. To my far right is Professor Newman. He doesn't need any additional introduction. Enough said. But just for people joining who might be new, to his left is Professor, it's hard for me to not call you Dean Minow, but Professor Martha Minow, who is a former dean of the law school. I will say much more in a bit. And to her left is Victor Madrigal, and he is the former independent expert on sexual orientation and gender identity at the UN. He's also a lecturer here now and a senior visiting researcher with the Human Rights Program. And finally, but not least, one of the founding students of the Human Rights Program is Jessica Neuwirth, who was identified earlier. Really great to welcome you here. I will say much more about your extensive experience and contributions in a bit. We're going to start with Victor. Yes, that's what happens when I lose a chair. So we have someone remotely, and my apologies. We have Karima Bennoune, who is a professor of law at the University of Michigan, and I will give you a proper introduction as well. Okay, so to Victor. Victor Madrigal, as I mentioned, is a senior visiting researcher with the Human Rights Program and a lecturer here at the law school. For 5 years, he had the mandate as the UN independent expert on the protection against violence and discrimination based on sexual orientation and gender identity appointed by the UN Human Rights Councils. His mandate ended in 2023, so he's recently given up that. Until 2019, he served as the Secretary General of the International Rehabilitation Council for Torture Victims, and he was also a member of the UN Subcommittee on the Prevention of Torture for 3 years between 2013 and 2016. Victor was rapporteur on reprisals and oversaw a draft on torture and ill treatment of LGBTI persons. He earned a degree in law from the University of Costa Rica. Victor's going to speak to us about tracing and preparing the evolution of standards that has grown over the last 75 years and how in particular that has really grown since the time that HRP has been around. So with that, over to you.
I'll do that in 7 minutes. Thank you very much, Tyler, and thank you very much. It's a great honor for me being here. I didn't think of myself as a particularly good student at university, so whenever I speak in academic settings, I'm mildly horrified for the last 30 years. I'm extremely thankful to be here because it's allowing me to actually do a big thanks to the Human Rights Program. When I was appointed independent expert, as Tyler was mentioning, I was also concomitantly the Secretary General of a rather large organization. And I was trying to do both jobs at once. And at some point, I remember I was in my home in Denmark, and I sat in my bed, and I said, oh, I think I'm going to die, but it's okay because it was for a good cause. And then something kind of appealed in my brain, and I said, no, it shouldn't be that it would be like that. And I devised the idea of coming with a construction where the mandate would not only have a political home in New York and Geneva, but an academic home at Harvard. And it was the Human Rights Program that actually allowed me to have that academic home. And through the Human Rights Program and the work of, I think, more than 40 students of this law school, the mandate crafted 12 thematic reports, the background notes for, I think, 5 country visits, and a number of inquiries that fed into the specific cases that I actually worked on and the specific inquiries. So as we take stock today, that is the kind of thing that, apart from everything else that you already knew, the Human Rights Program has created as an energy in this world. My successor, Graham Reed, the current independent expert, took that model and is currently implementing it in Yale. I don't know anything about rivalries between universities, but just so you know, that was done first here. Now, very quickly, I'd like to just make 2 references, and of course, I'm already way off track. The first thing that I'd like to mention is several speakers have placed us in 1984. 1984 was also the year in which HIV was identified as the causal factor for AIDS. There was criminalization of same-sex intimacy pretty much everywhere in the world, and there was no context of legal recognition of gender identity. And the idea that being LGB or T, the idea of sexual orientation or gender identity as points of entry into the analysis of discrimination internationally was not yet crafted anywhere in law. And I think that part of what has been a notable development in the last 30 years, certainly since the Tunen case, is that there has been a recognition that sexual orientation and gender identity are such points of entry into that analysis. I viewed it as my work to actually provide the building blocks of analytical work to make the case that this is part of international law. Not good practice, not good ideas, but simply and good international law under the Vienna frameworks and following the analytical frameworks, for example, of Article 38 of the Statute of the International Court of Justice. The fundamental frameworks for that development are United Nations based. And of course, in that sense, I always took point of departure in the Universal Declaration for Human Rights. This also has a very important point of connection with the work of Eleanor Roosevelt, of course, which is the one that has given the name to the fellowship that I have taken here at Harvard. I did promise at some point that I was going to be talking about some reflections about how Eleanor Roosevelt would actually have seen the situation if she had been placed here. I've amassed a rather significant number of scholarly works in her work, and also a Showtime series. And I have to say that I started with the Showtime series, so I don't have any conclusions to give you yet, but they are very enjoyable. However, what I can tell you in relation to this development is that since the Tunen case, mentioned for the first time in human rights analysis the issue of sexual orientation, that was done on the idea of privacy as the main driver for an analysis. And since that moment, a plethora of statements at United Nations have gone the way of understanding that being sexually diverse, being gender diverse, has implications in all realms of life. Not only at home, but also where you work, but also the place that you go and get your health care done, the way where you actually get your education, and the place that you get your education. And if this reminds anyone of a speech by Eleanor Roosevelt, is because those were the places that she identified as being the places where human rights made sense. And I think her idea, so rather than saying what would Eleanor say, I'm not saying following Eleanor and what she built, led the Indian Supreme Court only a few years ago to actually encompass all of this understanding of the political identity of being LGBT into the notion of this being mainly related to human dignity. Also another point of contact with the work of Eleanor Roosevelt. I would like to thank the Human Rights Program for having allowed me to do inquiries to actually follow that process and to give it substance. And of course, I'm very much looking forward to conversations in this relation. Catherine, my life is one of the things that gives me hope. I often say when I was born in Costa Rica, I was born a criminal, I was born under a diagnostic, and I was born a sinner, because criminalization, homosexuality was considered an illness and of course a sin. And then 50-some years later, I'm only a sinner. And I think that's quite some progress. Thank you very much.
Indulge me with one question, which is that the theme of our panel is equality. And I'm wondering if you can, that's been around as a theme for decades and decades. So can you place your work and the things that you've been working on in that broader context of equality?
Absolutely. I think part of what constitutes a very strong foundation in understanding not only the abstraction of equality, the way that it's actually interpreted, but also the understanding that it all takes point of departure in recognition by the law of juridical personality as the foundation for that. And I can give you the example, of course, of legal recognition of gender identity and the effects that it deploys in relation to accessing spaces, all sorts of spaces of equality, as one of the ways where international law has provided us the tools to actually analyze these issues. Now, I know very well how the members in this panel have worked very substantively and even in title-wise as to issues of equality, so I'm not going to pretend to go all the span. But I think that fundamental principle, again reflected in the words of Eleanor Roosevelt, is something that you can see today in all of the jurisprudence concerning sexual orientation and gender identity.
Next, we're going to turn to Jessica. So Jessica Neuwirth, I'm going to give you a proper introduction now. As I mentioned, was part of the core group of HLS students advocating for the creation of the Human Rights Program. Today, she is the Distinguished Lecturer and Rita Hauser Director of the Human Rights Program at the Roosevelt House Public Policy Institute at Hunter College. She was one of the founders of Equality Now, which has already been mentioned, an international women's rights organization established in 1992, and a leading one. This is a major organization in the field, and is the founder and director of Frontline Women's Fund. Jessica is also a founder and president emerita of the ERA Coalition. She has served as director of the New York office of the UN High Commissioner for Human Rights. Moreover, Jessica was the special consultant on sexual violence to one of the landmark cases at the ICTR, holding that rape is a form of genocide, and again at the ICTR on the media judgment, holding print and radio media accountable for their role in the Rwanda genocide. Following her work at the ICTR, she directed the legal team that drafted the judgment of the Special Court for Sierra Leone, convicting former Liberian President Charles Taylor of war crimes and crimes against humanity. And of course, she's a graduate of this law school. So that's quite a number of accomplishments, worth reading, and it's really an honor to be on the panel with you today. Today, you're going to focus your discussion on women's rights as a bridge to the intersectionality of various human rights areas of concern, including peace and security, democracy, and climate change. So with that, over to you. There you go.
Can you hear me? Okay, great. Thank you for that introduction. It's hard to believe it's 40 years. Makes me feel old. And you move it closer. Better? Just heard my life flash before me. It's a great moment to just kind of reflect being back here at Harvard. And I feel like we would be remiss at an anniversary like this not to pay some tribute to Clyde Ferguson. Because I guess if Henry was the father of the Human Rights Program, Clyde Ferguson was the grandfather of the Human Rights Program. And he is the person who inspired me to come to Harvard Law School. So I just want to pay tribute to him. And I know we're supposed to be focusing on the future, and yet we actually are talking a lot about the past, because we do want to understand the past and the present in order to think about the future. So I'm going to start by looking backwards as well. When I started Equality Now in 1992, as you said, there was no recognition in the human rights movement of women's rights. Human rights violations against women were generally dismissed as personal, not political, cultural, not criminal. They were classified by lawyers as non-state action and therefore excluded. Although I should note that other forms of non-state action, such as extrajudicial executions, were not excluded. Issues such as sex trafficking, female genital mutilation, domestic violence were simply not on the agenda of the human rights movement. And that was our goal in Equality Now, in part, to reframe these violations and bring them into the fold. So coming to the present, I think it's fair to say that there is broad recognition now that these issues do constitute human rights violations. There's recognition of the role of the state in the protection from and prosecution of violence against women. And there are a growing number of specific laws and international legal norms that have been formulated. But the real question, I think, is, are these laws enforced? If recognized, are these human rights respected? And while there has been progress, particularly in some development goals like girls' education, mostly, I would say not when it comes to violence against women and girls, other than in the creation of a more detailed normative framework. So we have the Beijing Platform for Action and CEDAW, the Convention on the Elimination of Discrimination Against Women, and together, I think they're an amazing and comprehensive blueprint for gender equality, and they've been reinforced again and again by the MDGs, the Millennium Development Goals, the SDGs, the Sustainable Development Goals, and so on and so on. There's a repeated recognition, but not much realization of these goals. And in fact now, I think we're seeing an alarming regression of women's rights. You may have seen recently women's groups in the Gambia have just managed to prevent the rollback of the law there banning female genital mutilation, or FGM. Although the law against FGM in the Gambia was passed in 2015, it was only used for the first time last year in a case where a circumciser was arrested and convicted for cutting 2 baby girls. The arrest enraged traditional leaders, who then got a preliminary vote in Parliament by a vast majority to repeal the law. And a campaign ensued that prevented this from happening, but that incident made it really clear that implementing the ban on FGM to actually stop the harmful practice is not going to be easy. And an effort in Sierra Leone recently failed just in the last few weeks to amend the Child Protection Act to include FGM. A number of girls have bled to death from FGM in recent years in Sierra Leone, and that is no doubt, there are no doubt many more that we don't know of. We're all watching the rollback of women's rights here in the United States as well, and we can't even get the Equal Rights Amendment into our Constitution, a very simple non-discrimination provision that is in most other constitutions. As you probably know, we're one of a handful, 7 countries who haven't ratified CEDAW, the International Bill of Rights for Women. What's happening in Afghanistan is a complete travesty. After 20 years of women serving as lawyers, judges, and ministers, the Taliban is back in power. And virtually every week, there is a new decree preventing girls from going to school, women from working, singing, going to beauty salons or parks, and now even from being seen and heard in public. And the international community has not been at all effective in stopping these most fundamental violations of women's rights. And you do have to wonder, if it was boys who couldn't go to school just because they were boys, and men who couldn't work just because they were men, would there be so much patience and engagement with the Taliban by the rest of the world? So I think the present is a little bleak, as we've been saying. And turning to the future, and I think Catherine kind of stole my thunder on this, I do think we need to focus less on the development of new legal norms and more on the implementation of existing law. But I don't think that's a given. I think that lawyers like to write laws. I think it's more interesting and creative and intellectually challenging. And the enforcement is kind of tedious and difficult and maybe less interesting. But I think it's really more important. There's a lot of talk about a new CEDAW protocol on violence against women, a big effort to recognize gender apartheid as a crime against humanity. And these are important, of course. But I do think the greatest need is the implementation of existing legal norms, much more so than addressing gaps in legal norms. And just imagine, what would the world look like if all the obligations of CEDAW were fully complied with and the recommendations of the Beijing Platform for Action were fully implemented? I think it's almost unimaginable, and it would be pretty great. So we need to look at also why the legal framework is not working for women. And I think the Me Too movement has raised awareness of sexual harassment to an exponentially new level. But it's still very difficult for women to win their cases in court. That has not changed a lot. Accountability in the age of Me Too has had much more to do with career consequences than legal consequences, public shame more than successful prosecution. So we have to continue to try to address these obstacles. And in my experience, the judges applying the law have more to do with the obstacles than the law itself, very often. As mentioned, I worked on the Akayesu judgment of the International Criminal Tribunal for Rwanda, a judgment that is very much lauded for its finding of rape as a form of genocide. But it was hardly a stretch legally to find that rape constitutes serious bodily or mental harm, and therefore genocide. I mean, that's pretty straightforward. But without Navi Pillay, who at that time was the only woman judge in the tribunal, there is absolutely no doubt in my mind that this finding would not have been made. And I should, of course, note that it was through Harvard Law School that I first met Navi in the early days of the Human Rights Program. So looking to the future, I think we need more women in power and more public pressure to create the political will needed and currently lacking to implement existing norms more effectively. And last, but certainly not least, we need more funding to get to more frontline women's rights advocates. And that's what I've been focusing on through the Frontline Women's Fund, an initiative I started a few years ago. According to OECD, less than 1% of funding earmarked for gender equality goes to women's rights organizations, less than 1%. We have the understanding and we have the vision, but the movement has not had the money to really move the agenda forward. We can look at the progress that has been made, but I think the measure that really matters is whether the lives of girls and women have actually changed. We live in a world where sex trafficking, female genital mutilation, rape, and domestic violence are killing countless girls and women every day in countries around the world, including our own. And by that measure, we still have a very long way to go.
So I'm going to come to you with a question as well. I can imagine how having more women in power would change the judiciary, for example. I think that connection is very clear, and I understand it. A piece I would want to hear more about is what would the frontline funding support, if you could unpack that a little bit more. Are there strategic places where it's most important, for example, the types of funding?
I think in every country, I mean, including our own, we look to the people most affected to really understand what the problems are and what the solutions might be. And I have had the privilege of just meeting countless amazing women's rights advocates around the world that are working on what I call the front lines at the grassroots level, at the national level. Mostly they're pretty unknown and they're completely underfunded, but they have a very clear vision of strategy. And to be honest, I think what happens is a lot of times the way the money flows, you'll end up with a lot of international organizations getting funding for the work that they end up turning around and relying on some of these women's groups to do. But those women's groups are really pretty disempowered. They don't really get to feed into the strategy of what it is that's going to be most effective. And you know, a lot of these issues are very culturally sensitive. You take an issue like female genital mutilation, and there's a lot of focus on measurement. You know, how do we measure impact? And when you talk to some of these frontline women, you know, who have been out there in villages trying to educate people, they'll just tell you there's a huge number of people, the minute they understand the medical consequences of FGM, that is actually why their daughter died, that it wasn't some spirit, that it was really just she bled to death because someone cut her with a razor, they'll stop. You know, there's a lot that can be done through simple education. But these same people who could do that education, which I think they're best off to do, they just don't have the funding to do it. And they're not good at measuring. They're not, you know, we still don't know how many girls die from FGM. Like, I just anecdotally ask people all the time, is it like 1 in 5, 1 in 10? It's a huge number that probably feeds into the disproportionate lesser number of women that has been documented in the world. But I think that the funding would go a long way to level the playing field for them and to give them the visibility they need. And we try to also, in addition to funding, give them access to forums like the UN. We just recently had a bunch of Afghan women leaders at the UN, you know, really just talking from their minds and their hearts about what's happening there. And I just don't think that anyone can do that as well as they can.
It really gets back to your theme about transferring the power to the front lines and not just the judiciary. Yeah, I see the through line there. Okay, thank you. Next, we're going to turn to Martha Minow, who holds the 300th anniversary university professorship at Harvard University, and is one of 25 professors accorded this highest academic post at the university. She has taught at Harvard Law School since 1981 and served as our dean for 8 years, between 2009 and 2017. An expert in constitutional law and human rights, her work has focused on issues confronting historically marginalized individuals and groups, legal responses to social, political, and religious conflict, and legal treatments of digital communications and technologies. I'm not sure if I should say where you got your JD. From Yale Law School. Martha's going to speak today about a pretty different angle on this and discuss the challenges and opportunities for human equality posed by AI.
Thank you. You know, it's so appropriate that many people have expressed gratitude and acknowledgement of people who were critical to the founding of this program, because it is a program of human rights, and it is a human set of connections that have made the program as meaningful as it has been, always putting people at the center. I'm delighted Jessica mentioned Clyde Ferguson. I was thinking about Clyde as well. And Henry, your willingness to turn your career into this subject made the subject. And it certainly, as you're hearing, changed the lives of so many, many people. And Jerry and Tyler, thank you for what you do to keep it alive and growing all the time. I'm grateful to everyone for being here. What a wonderful panel. I'm honored. Yes, I've been thinking about AI, artificial intelligence, and the particular challenges and opportunities that it poses. And because this panel is about equality, that will be my focus. This sentence was not written by ChatGPT, but it could have been. Frankly, I'm focusing on these issues about AI because I think it's the emerging frontier for human rights and civil rights. What do I mean by AI? The OECD, the Organization for Economic Cooperation and Development, said AI, and I quote, is a machine-based system that, for explicit or implicit objectives, infers from the input it receives how to generate outputs such as predictions, content, recommendations, or decisions that can influence physical or virtual environments. It's so many words. What it is changing our lives. I mean, I don't know how many times you've clicked on your phone something today. That means that you're under surveillance. That means that there is control of your life that is unimaginable from the past, from 1984. Many uses of AI can be advances in human welfare, such as facilitating the understanding of proteins and speeding the development of therapeutic drugs, addressing hunger by analyzing millions of data points to identify the locations where crops are failing, and even offering conversations to ease the loneliness of a child who is isolated during treatment for cancer. There are remarkable developments. But this last example, the robotic AI who gets to know a child and the child builds a relationship and they have conversations, that also is a hint of the dangers. Recent research shows that young children, even more than adults, are more vulnerable to trusting AI chatbots too much, investing in them, confidence, belief, really confiding in them, and disclosing information about their own mental health to a friendly-looking robot more than they would to an adult. But let me tell you, however impressive the chatbots are, they do not have empathy. They do not have understanding. And depending on who's in charge, they don't have the child's interests at heart. Even more basic problems arise due to mistakes and deception, like when Amazon's AI voice assistant, Alexa, instructed a 10-year-old to touch a live electrical plug with a coin. And when Snapchat's My AI gave adult researchers posing as a 13-year-old girl tips on how to lose her virginity to a 31-year-old. These findings and the companies behind the AI tools that have worked on improving the safety settings are real. But child safety, like other concerns, are too often an afterthought in the development of AI and their rollout and frankly, in their marketing. Another class of concerns arise under the rubric of privacy, given how AI and indeed digital tools enable surveillance, and the equality dimensions are so profound. Equal treatment, freedom from discrimination on the basis of personal traits, including race, gender, sexual orientation. One of our doctoral students right now, Mauricio Levesque, has further identified a new digital divide between those who can bypass AI because of their privilege, their wealth, and the rest of us who have automated systems and we're lost in automated hell. She calls it analog privilege. And I think we're all going to be living through that. When can you get to talk to a human being as opposed to AI? Inequality of this sort will increasingly affect who's allowed to participate in key decisions affecting one's own life. Decisions about employment, schooling, obtaining a loan, pricing of consumer goods, triaging urgent patient care in a hospital emergency room. They're all, right now, this is not pie in the sky, they're all being managed in many parts of the world by AI systems. Earlier this year, Volker Turk, the UN High Commissioner for Human Rights, remarked, and I quote, "The unparalleled human rights impacts of advanced AI, including generative AI, are already being felt by vast numbers of people, People must be at the center of the technology, he urged. And I love that idea. I just don't know how to make that a right or make that something real. It's just not true because it is being developed by private, profit-making companies, and it is the new gold rush. It's where resources are going all over the world. In addition to the risks of dehumanization and invasions of privacy, the world may see increasing divides between those without the resources to opt out and those without the resources to actually have any choices in their life. In 2023, political leaders adopted the International Guiding Principles on Artificial Intelligence and a voluntary code of conduct for developers under the Hiroshima AI process. It's awaiting decisions, it's awaiting implementation. This is a step. The UN has developed some papers and frameworks and guidelines. This is all resting on the voluntary action of the for-profit companies, all of it. And the most stringent binding law right now dealing with AI is the EU AI Act that bans certain activities, including cognitive behavioral manipulation of people, real-time remote biometric identification systems, but there's exceptions, for example, for law enforcement. So even this, the most binding law in the world right now to deal with AI is quite limited. And as my friends at MIT tell me, it's already out of date. I'm not a technical expert, but there are potentially even more profound challenges for human rights posed by AI. Deep fakes, I think we've all encountered them. Images and recordings, audio material created manipulating the images of real people, creating synthetic people. The next issue that's not science fiction anymore is whether AI chatbots and their equivalent deserve rights themselves. I'm not ready to go there. I think that we should really focus on the humans first. And yet it's not pie in the sky to be thinking about the dystopic possibilities that AI could take control of many aspects of human life, not only in violation of the UN Declaration of Human Rights, but in violation of just humanity. It's no longer the domain of science fiction writers to be warning about the extinction of human societies and even humans due to potentially deployment of AI, particularly in weapons systems. So what to do? I think that one thing that I would strongly suggest is thinking about responsibilities. And to build on Catherine's wonderful remarks earlier today, to think about existing treaties and documents and institutions that are already in place that are being jeopardized by AI and by AI's implementation. The impact right now of AI on energy usage, the impact on water supply, the impact on the miners who are engaged in having to get the precious metals that are used in the materials. These are just fundamental. Some of them are first generation, some second generation human rights. This is not fancy human rights. There are potentially exciting opportunities. I am not a technophobe. AI could offer personalized tutoring to enable any person anywhere in the world access to the world's knowledge. The initiative developing refugee education for children 3 years and under has depended on AI and the use of digital tools. There are tremendous opportunities here, but the question is, will human beings be the ones in charge? And as we navigate these challenges, the focus on human rights, I think, is essential to help individuals, groups, and countries, and even companies. Beyond the AI excitement and the hype, the framework of human rights puts humans at the center, and I hope that that can remain the case and become more realized, so that AI is shaped by humans, for humans, rather than AI shaping human rights. Thank you.
So much to unpack there, and we will have questions at the end. So let me see if I can pick out one follow-up question for you. So because of the impacts are so diffused and ever-present, I think with Victor and Jessica, we could say there was definitely a human rights movement going along with all the legal norm development, enforcement fights, et cetera. What does a human rights movement look like with AI?
Yeah, it's a terrific question. One of the challenges to any law or any norms in this context of AI is the speed of the development of the technology. And so, I think that human rights advocates have to become conversant in AI and use it. I've been talking with people about the Defense Administration in this country, the State Department. Is AI being used? Of course it is being used. So the question is, what do human beings know and how are they using it? And I think that it's incumbent upon the human rights movement to become users of AI and critics of AI.
I think we'll come back to that during questions, but so we can keep going. Okay, Karima, you can hear us? Okay, very good. All right, so Karima Bennoune is the Lewis M. Symes Professor of Law at the University of Michigan. She specializes in public international law and international human rights law, including issues related to culture, extremism, and terrorism, as well as women's human rights. Karima served as the UN Special Rapporteur in the field of cultural rights for 2 terms from 2015 through 2021. She was also appointed as an expert for the International Criminal Court in 2017 during the reparations phase of the groundbreaking case, the prosecution of Ahmed al-Fahiq al-Madid, which concerned intentional destruction of cultural heritage sites in Mali. Karima holds an MA and JD from the University of Michigan, and she plans to speak today on the effective international responses to extreme violations of women's human rights, such as the current situation in Afghanistan. So over to you.
Thank you very much for that kind introduction. I'm assuming that you can hear me.
We can.
Yes, great. Thank you. And I'm sorry not to be with you in person. I want to congratulate the Harvard Human Rights Program on its important anniversary and celebrate its many achievements. And before I get to my main topic for today, I feel compelled by the news in recent days to start off by saying that I think one of the single greatest challenges to the principle of equality globally at the moment is the inconsistency in the application of human rights. And I think we are seeing this imbalance on display again in the bland reaction by some Western countries, including the United States, to the horrific toll of civilian casualties in Gaza and Lebanon. Nizar Ghanem, who is a policy analyst in Lebanon, recently said on The World on NPR what I think many around the world are now thinking, which is, quote, if you are an Arab, a Middle Easterner, you are outside the realm of international law, unquote. And I think this concept of some people being outside of the realm of international law and human rights is an incredibly dangerous and divisive one. Dehumanization enables tolerance of mass casualties among certain groups of civilians who become a kind of dehumanity, a nameless, faceless third world body count. And I think this weakens the very foundations of the principle of equality, and it's something we have to address. And I rush to say that we, of course, see a similar dynamic in the rhetoric of some who have justified the atrocities of October 7th in the name of resistance. All of this is directly counter to the core truth of Article 1 of the Universal Declaration of Human Rights, that we are all born free and equal in dignity and rights, a concept which we need to reaffirm again and again. And this brings me to my main topic, and I'm just going to try to get my PowerPoint on very quickly here. And show a few slides so you don't just have to look at me on the screen. I'm assuming you can see the PowerPoint.
Yes, we can see it.
Great, thank you very much. So what I want to focus on with the rest of my time is the challenge to the right to equality posed by what the German Foreign Minister Annalena Baerbock has called the biggest violation of women's rights on earth, which is the situation of Afghan women under ever more draconian Taliban rule, and also the failure of the international community to respond effectively to it. And so my presentation really builds on what you've already heard from Jessica Neuwirth. So the situation in Afghanistan obviously has grave consequences for the nearly 20 million women still in the country, and it also has implications for the protection of women's rights everywhere. And I'm going to try to run through a few of these aspects quickly in my time. So I really see the situation in this country at this point as representing a kind of crucible of women's rights in 2024. And I almost feel like the best way for me to explain the situation to those who aren't working on it might be to simply be silent. And this is because, as Jessica's already alluded to, things are so bad for women in Afghanistan that, in fact, the sound of their voices in public has now been banned by the Taliban in an Orwellian new law on the promotion of virtue and the prevention of vice. And of course, this builds on more than 100 decrees that we have seen in which the Taliban have stripped Afghan women of most of their human rights. Now, Afghan women have defied all of this, including the ban on their voices being heard in public, by almost immediately engaging in a very courageous campaign of singing and reciting poetry and even reciting the Quran on the internet, and some very dangerous clandestine singing in public, which is, of course, a reminder to stress the point that Jessica made, that Afghan women human rights defenders are and always should be in the lead in tackling this human rights crisis. And yet, at the same time, they repeat again and again that they are in grave need of global solidarity. And I want to think about what international human rights legal solidarity looks like in this particular moment. One of the greatest concerns that I've been hearing from Afghan women human rights defenders is that, in spite of the fact that the Taliban have done all of this openly, they have done this in ways that could be described as de jure and in plain view of the entire world. We are seeing increasing normalization of the Taliban, increasing efforts to sort of get them to the table, to engage in de facto recognition of them. The worst example of late being the willingness of parts of the UN bureaucracy to hold meetings with the Taliban in the Doha 3 conference without the presence of Afghan women or without their rights even being on the agenda, because that is what the Taliban demanded. And I think this normalization, this international failure, is a very grave threat to the entire concept of women's equality and the whole women's human rights project that Jessica addressed. So I think having an international legal response to this normalization is critically important, because this kind of unacceptable acceptance of the worst kind of discrimination against women weakens the entire international human rights framework to the detriment of women everywhere. And it has national, regional, and global repercussions. And I think of what the Human Rights Watch researcher Heather Barr wrote quite rightly. She wrote that the weak international response to the return of the Taliban in Afghanistan has implications for women everywhere. It tells us how little we and our rights are respected still. And following on from her conclusion, I feel as an international human rights lawyer that the consistent failure to enforce international legal principles on women's rights in a situation of this gravity really risks undermining the entire project. It is a kind of test for the international community. So to quote Tolstoy then, what then must we do? How do we tackle this kind of oppression of women? And I'm very much persuaded by Richard Bennett, who is the UN Special Rapporteur on Human Rights in Afghanistan, who has consistently emphasized the importance of what he calls an all tools approach, because he stresses that no single approach is likely to reverse or mitigate the Taliban's regime of gender oppression by itself. So here we have to use all the legal tools that we have. And I think that is something that builds from the theme of the keynote, though I wasn't privileged enough to hear it. But we also have to identify gaps in the international legal framework that we need to fill to be able to address the specificities of this situation and to respond to the understanding that many of the victims of these policies have of the human rights violations they are experiencing. And I'm just going to run through very quickly what some of the tools in the toolkit that we need are. First and foremost, obviously, we have, thanks to the very active Women's Caucus for Gender Justice in the ICC, we have the prohibition on gender persecution codified in the Rome Statute. We need to see, and I hope we will soon see, charges brought against Taliban leaders for gender persecution, a critically important crime which surfaces the linkages between discrimination and severe harm. But we also know from looking at recent examples in the ICC, such as the El Hassan case, unfortunately, it is also difficult to get actual convictions for this crime. So a great deal of work to do here. We need to use all the other tools currently in international law, cumulative charging of other crimes, exploring the application of the prohibition on enslavement. This is a suggestion that's been made by Patricia Sellers, using universal jurisdiction, litigation before the International Court of Justice under the CEDAW Convention, some states are trying to take forward, and exploring all the avenues available using all the human rights treaties to which Afghanistan is a party. And yet, the toolkit still is incomplete. And this is where I want to turn quickly to the concept of gender apartheid and how important this concept has become in the work of many, many Afghan women human rights defenders, and how the international community needs to really respond for their call for codification of this crime, because it describes the very specific harm which they are facing. It surfaces the ideological nature of that harm, which is basically a system in which extreme discrimination against women has been made the form of government. So the persecution is the governance model. And I think this is a critically important concept that we need to add to the toolkit. Gender apartheid, I've described in work that I've done in consultation with Afghan women human rights defenders, is a set of laws and policies that imposes systematic segregation and exclusion on women. It's a kind of systemic oppression that really involves defining women as being not as human as men. In this way, it mirrors the experience in many ways of victims of other forms of apartheid. And here we're really borrowing from the international law on racial apartheid. And I'm going to jump forward very quickly just to stay within my time. And we're also carrying on from a tradition that goes all the way back to the late 80s and the 90s of women human rights defenders, in particular in Muslim majority countries, using this construct of gender apartheid to surface the political nature of fundamentalist oppression of women. And I think it's no accident that the first UN expert to use the concept of gender apartheid is Abdel Fattah Amour, who you see on screen, who was then the UN Special Rapporteur on Freedom of Religion or Belief, who was from Tunisia, and that's a Muslim majority country with a fairly liberal approach to women's rights. And he recognized that this was a question of political choices and political ideology, not just religion and culture. And we're seeing that in recent years, including many women human rights defenders from Afghanistan, from Iran, have been using this concept, but they've also been getting critically important support from past victims of other forms of apartheid, including many non-white feminists from South Africa, including Graça Machel, the widow of Nelson Mandela, who endorsed this vision of what's happening under the Taliban as a kind of gender apartheid, and called for an international response to it, akin to the response that ended de jure apartheid in South Africa. And I think that, for me, is the critical added value here that I want to mention in the short time frame. And that is that what we do not have currently is an international norm or standard that allows us to constrain the behavior of other states in how they respond to an actor like the Taliban. And so I think the most important added value here of borrowing from the apartheid framework is to put pressure on other governments, international organizations, and even companies not to engage with the Taliban in ways that show tolerance for and help to perpetuate grave abuses. And in terms of moving forward, we need to apply the existing apartheid conventions and standards to gender apartheid. So this is a way of using existing law with a forward-looking, gender-inclusive interpretation. And I can cite some examples of that. You see one on screen. But we also have an urgent opportunity, and that is the drafting of the Crimes Against Humanity Convention, which we hope will move forward in the 6th Committee of the UN General Assembly. And 10 states from different regions have made the proposal, or at least raised the possibility of including gender apartheid in the definition of apartheid that is already in the draft of that convention. So to conclude, let me say that I'm very inspired by those who are on the front lines of fighting for equality around the world today, and in particular by Afghan colleagues. And I believe that one day they actually will put an end to Taliban repression of women. They have not given up on the concept of equality. And I think the international community, looking at their country, sometimes has. I think the real question is whether Afghan women and others in Afghan society who oppose the Taliban will actually achieve this goal of moving away from this kind of rule with the help of the international community or in spite of the international community. And I think that is what will really determine how long it takes. And to end, I reflect on the words of Zubaida Akbar, one of the women I interviewed for my article, who said the international community should hold by principles they claim they have. And I think that's an absolutely central idea to the defense of the right to equality today. Thanks so much for listening.
Karima, a number of questions come to mind, so I will hold them. But the one that I wanted to ask you in the follow-up was, does the need to name and pursue gender apartheid as a normative and legal construct indicate something about the failures of equality more generally, that we have to move into essentially an international crimes framework instead of just a human rights framework? That'd be one take on that. And what is that saying about all of the other dimensions of equality and the status? Is that an institutional failure or is it a normative failure?
That's an interesting question. And I guess I would say that ultimately, I think the failure is to recognize the distinct nature of situations in which de jure inequality abounds. And in those kind of situations where you have such a strong ideological commitment to discrimination, indeed discrimination is the model of government, then you can't use the usual human rights model. The usual human rights model is that sort of international legal bodies, treaty bodies, and so on, work to try to convince the state on the ground to implement its obligations with regard to the principle of equality. That is utterly impossible in a situation like the Taliban. And that is where the international piece becomes critically important. And I think we need to think about equality, and maybe this is also where I started my remarks, not just within national borders, but also as a transnational concept that needs to be implemented both domestically and with transnational support.
Thank you. Thank you. Okay, we're going to close then now with Jerry Newman, and I'm not going to reintroduce you, but I'm going to thank you for being a good colleague and a mentor to me through the years as well. And I'm going to hand over to you to bring us in for a landing around the issue of indirect discrimination and some of the things you've been researching in that area.
Thank you. Is my microphone doing its job properly? Maybe not. So thank you, Tyler. And more broadly, I want to continue to deflect thanks onto prior leadership of this program. As always, Henry, who founded and set the course of critical engagement with human rights, critical engagement with human rights problems in the world, as we've been discussing, but also critical engagement with the human rights regime and the ways in which the human rights regime needs to be criticized, sometimes for doing too little, and sometimes for doing too much, and sometimes for doing things badly. But that none of that can be off the table for intellectual discussion. And other predecessors who I have had, some of whom are with us today, that includes Tyler, who led the Human Rights Program before I joined it and led it with me during the first part of my directorship. That includes Ryan Goodman, who will be speaking on the second panel. And I'm not asking you to applaud at this moment, but I want to express those thanks for all that we've been able to achieve with them and after them. My topic on the subject of equality is the perhaps not surprising topic of racial equality. Racial equality, one of the oldest issues of the human rights movement and the post-World War II human rights framework. Racial equality, the subject of the Convention on the Elimination of All Forms of Racial Discrimination, which was the first of the core human rights treaties to be completed before the covenants. And I want to add that under that treaty, racial includes national or ethnic origin. This is an old issue. It is unfortunately an internal issue and a new issue that may be becoming worse in the world over the next decade. It is an issue that involves not only north-south discrimination, but also south-to-south discrimination and north-north discrimination. The Human Rights Program has focused on this issue in recent years, both within the United States, where there have been a variety of developments and legal backtracking, and transnationally. And last spring, we hosted a convening of the recently created United Nations Permanent Forum on People of African Descent. The convention prohibits both direct discrimination and indirect discrimination, or in US terms, one might say disparate treatment and disparate impact, de jure and de facto discrimination, formal and substantive discrimination. HRP has held a series of events examining the concept of indirect discrimination. But for racial discrimination, achieving substantive equality is particularly important, although United States constitutional doctrine has been rather indifferent to that achievement, and in recent years, in some respects, downright hostile. At the global level, the CERD Committee has long held that its treaty prohibits both direct and indirect discrimination, and it employs the usual international standard for defining discrimination, namely that indirect discrimination involves first a practice that disproportionately disadvantages a group, and secondly, that the practice is not justified by serving legitimate objectives in a proportionate manner. Catherine referred earlier today to the International Court of Justice, and unfortunately, I'm going to have to bring the International Court of Justice into the conversation here. I guess there was also reference to hope of involving the International Court of Justice on other equality issues. But unfortunately, a disagreement that can be quite disruptive has developed between the International Court of Justice, or at least its majority, and the Third Committee regarding the meaning of discrimination. Here I'm going to get technical, but I think the issue is important enough to get technical about. There have been a long series of recent cases before the International Court of Justice that involve the Third Convention that are binational cases brought by one state against another in the context of a larger dispute in which claims of violation of the Third Convention form a part. This has been going on for a number of years, and one of those cases came to fruition in 2021 as the case of Qatar versus the United Arab Emirates, in which the complaint was about practices that the United Arab Emirates, as well as a number of other Gulf nations, had adopted as a result of a dispute with Qatar, targeting Qatari nationals. And the International Court of Justice held that nationality as such, current nationality, does not count as a form of racial discrimination under the Third Convention, and in particular that national origin does not include within it the concept of current nationality, particularly when direct discrimination is the focus. The court reasoned at some length about that. But then it also briefly addressed the claim that the same issues could be raised as a matter of indirect discrimination. And rather briefly and dismissively, the court concluded that the discrimination before it was not based on national origin, but rather on nationality. This dispute that was opened up here, which was an important dispute for the human rights system also, in that it involved the explicit rejection of the understanding of the treaty by the treaty body, which is the normal interpreter and monitor for the treaty. This dispute was expanded in January of this year in a case of Ukraine versus Russia. That was a case that Ukraine had brought against Russia under an international terrorism convention and the Third Convention, arising out of Russia's invasion of Ukraine. And the relevant issues here particularly involve the situation in Crimea. So it's not the 2022 invasion, but it's still the 2014 invasion at issue here. And the reason that this was the source of the claims is because of the way in which those treaties provided for jurisdiction in the International Court of Justice that Russia had not excluded. So it was an available vehicle for bringing the dispute before the International Court of Justice. There, the majority held that the discrimination against Ukrainian speakers in Crimea and against Crimean Tatars in Crimea, variety of different violent and less violent forms of discrimination, were not indirect discrimination because they were not based on ethnicity if Russia could point to some reason other than ethnicity that was the basis of its action. For example, the political activity of the actors. Now, you might think that targeting people on the basis of their political activity would also be an important human rights issue, but the court said that it couldn't inquire into the legitimacy of the action, and it did not inquire into the proportionality of the action, because these were just not issues cognizable under the Third Treaty. So what the court did in that case was largely to reduce indirect discrimination, the prohibition of actions with discriminatory effect that are disproportionate, to direct discrimination. And what the court was doing seemed to be motivated by its concern with being burdened by these armed conflict cases that are so difficult for the court to resolve, and in which there's so little likelihood that the court's judgment will be observed, but that are being brought before it under the rubric of the Third Convention. Now, there may have been some change visible this summer in the court's advisory opinion on the legal consequences of Israel's occupation of the Palestinian territories. That was a response to a request from the General Assembly to opine on the legal consequences of the occupation. And the General Assembly's request opened out for the court to address a wide range of international law norms under which the occupation and the practices of the occupation were being challenged. There, the majority in the ICJ found a variety of discriminatory practices that Israel was committing to be violations of CERD, and among other things found that its practices in the West Bank could not be justified as designed to protect settlers in the West Bank because the settlements violated international law and therefore did not provide a legitimate objective for the harms that were being inflicted on the Palestinian residents in the West Bank. In one sense, this method of analysis does not contradict the judgment in Ukraine versus Russia, because the court had a wider range of jurisdiction that it could call on. But it doesn't seem reasonable to say that whether something is a violation of the CERD Treaty or not depends on what other issues the particular court that's deciding the issue should be authorized to rule on. So I hope we may be seeing the beginning of a course correction which will bring the International Court of Justice more into line with human rights law. I don't mean uncritically agreeing with everything the treaty bodies say, but more into line with the normal international understanding of the law against racial discrimination, and playing a constructive role in that regard. The world needs robust prohibition of racial discrimination, both direct and indirect, in the current environment for reasons that other members of the panel have referred to, and that may multiply to the extent that more countries fall under far-right governments in the near future. And that requires the use of all tools, including a proper understanding of indirect discrimination that includes both the elements of legitimacy and proportionality. Thank you.
Jerry, just a quick question follow-up, since I've asked everybody else one. I want to take my privilege as a moderator. My question is whether this course correction or the detour that the ICJ has taken is being seen in other places with regards to the direct and indirect, or are you noticing it just in this particular context of the armed conflict that you identified? Is it a broader debate?
So I will say first that others have noticed the problems that I'm talking about with regard to the divergence between the ICJ and the treaty bodies. Perhaps not analyzing it in the same way that I analyze it, but yes, it has been noticed. These cases included dissents. Judge Iwasawa dissented in the Qatar case. Judge Charlesworth dissented with a lot of attention to the issue of indirect discrimination in the Ukraine case. I don't think I've seen anyone having picked up any relevance to this of the advisory opinion this summer on the occupied territories. Understandably, I'm focusing on what could be considered a minor aspect of a truly major human rights problem about which people have much more to say than focusing on its relation to the problems people have noticed in these other cases before.
Okay, so I think we have time for a round of questions. And why don't we do a round so then we can have some closing thoughts? One here. Why don't you start, and hopefully some other people will have some hands while you start.
Thank you so much for such an inspiring and fascinating panel. First, let me also express my deep gratitude to Henry. I was a visiting fellow in 1995 to the Human Rights Program, and thank you to your generosity, who's also changed my life. So I'd like to pay this tribute. My question relates to Martha Minow's contribution on AI and human rights. I do agree that AI, on one hand, can promote human rights, on the other hand, can violate human rights. I also agree about the multidimensional impact of AI, from election to rights of children and online discrimination, hate speech, different spheres. And you end up asking what to do. You made a point about endorsing responsibility. And I'd like to hear more about your views on AI, the impact of AI on human rights, and the impact of human rights concerning AI. Especially, I do believe that the lack of response, of legal response from the humanities science, I think there is a lack of response, and this lack of response results in human rights violations. So that's the picture that I see. We have the, as you mentioned, EU binding law, which was adopted this year. We have the decisions of the Supreme Court of the US saying there is immunity. In my country, we are debating, Brazil, we are debating regulations everywhere. At the UN, we have the guiding principles, UN Business on Human Rights. So what is your view? Just closing our eyes and thinking that 2064 will be here, in this journey of time, 40 years, how to strengthen the human rights approach concerning AI. Thank you so much.
Thank you for the question. Should I go ahead or do?
Why don't we
take another. Okay.
Well, I'm going to follow up on that one for Martha, since she's going to talk anyway. So one, is the Human Rights Program working at all on AI yet? No. Okay. And if not, since we're talking about the future, I want to nominate this.
Catherine, can I just interrupt?
Yes.
I have a chapter coming out in a book
Okay.
on the right to a human decision.
Yeah.
And I think you'll be interested to hear on the subject of to what extent do the existing documents already provide elements that deal with some aspects of the right to a human decision.
Okay.
I'd be happy to send you.
I'd like to see it. And all the more reason I want to nominate this as an issue that the Human Rights Program should be working more on. One, because the United States is by far the biggest actor, so it really makes sense to have this work happening here in the U.S. Two, because Cambridge is the right place to be, since you've got colleagues here and at MIT and other places, and it's just, I think, anyway, just a very, very important issue the way Martha was raising it, and something that I think needs to be worked on by a human rights program.
Well, I welcome other people's thoughts about this. Thanks for these comments and questions. Jerry's chapter is excellent. It does make me think about Brazil, which is in many ways the leading country in the use of AI in the courts. And so it makes the issue of a right to human beings, where in the loop is the human being, very, very salient. Just to be clear, in Brazil so far, there's no ultimate decision that's being made by AI. But AI is being used in triaging cases and being used by judges to sort the precedents. Frankly, I understand that. There's backlog. There's serious problems that the courts need to deal with. That's why Jerry's approach is so very central. If there is not a human being who is at the center of the decision-making, I do worry. And why, among other reasons, I worry because, to take our panel's theme quite seriously, AI is fundamentally a prediction device based on data, based on the past, based on human behavior. But it also looks for patterns and amplifies them. So the discrimination patterns of the past by human beings is what AI amplifies and escalates, often looking indirectly. It's not intentional, but it ends up being very, very salient. So I agree it should be a very central concern for a human rights program here, human rights activists.
My name is Marcin Kilanowski. I'm a professor of law from Nicolaus Copernicus University in Poland, and also a graduate from the Human Rights Concentration, LLM 11. It's wonderful to be here and to celebrate this anniversary. And I would like to ask, as a follow-up to Professor Minow, Dean Minow's answer to the question, and I would like to say that nowadays in Europe, lots of scholars are pointing out to the need to right to truth, a constitutional right to truth, knowing that the AI amplifies certain voices which are there, and knowing that there is so much untruth that is said by populist governments and who have their own agendas. Kind of a response, a possible response would be to develop a right to truth. But of course, there is a worry who is going to protect the truth. And being from Poland, we've been in the system in the past where the truth was protected by the government, but that was not a full truth about the reality. So that kind of proposition has particular, there is some possibility of protecting a wider perspective on things, but also it could be used against it. I would like to ask you, what do you think about it?
I think we had a couple other hands in the back.
Thank you so much for an excellent panel. Jennifer Chidgel, visiting doctoral student from the University of Cambridge, and relevantly for this panel, former advisor to the then UN Special Rapporteur on Freedom of Religion or Belief, Dr. Ahmed Shahid. I've got two questions. One is for Jessica. You mentioned at the end of your presentation that less than 1% of global funding is going towards women's rights organizations. Have you seen this situation changing for better or worse in recent times? And in particular, are there any trends in what issues are receiving the least amount of attention and funding? And to Victor and Karima, in all our shared experiences with UN special procedures, there's an ongoing discussion about the relationship between the Office of the High Commissioner of Human Rights and special procedures. I was wondering if you would care to share 2 or 3 ideas as to how the office can continue to best support the mandate whilst furthering the independence of special rapporteurs, noting that the mandate is, for all intents and purposes, independent, and that includes independent from the office itself. Thank you.
I think we have 2 more. We have one other hand in the back, and then Henry.
Hi, my name's Thomas White. I'm an LLM student from South Africa. I had a question for Professor Newman related to the Qatar decision. Now that the ICJ has proven itself to be a little less differential to the decisions of the human rights treaty bodies, I wanted to know if you think this restricts the interpretive scope that these bodies will have in future cases, particularly insofar as it might concern parties that are not parties to the dispute before the ICJ cases, where the jurisdiction was essentially restricted.
Mike.
Very fortunate. My voice has taken a tumble for the softer over the many years. I wanted to thank Jerry and the program for presenting this excellent, not quite synopsis, but variety of views on matters very deep to human rights thinking, and for having done so well in developing the program during its now numerous years as the human rights institution of the school. One of several thoughts I have hearing the different views expressed is one that hasn't come up directly, but I think inheres in several of the presentations. I'm wondering why phrasing a problem that is perceived, say, as very grave by many, like racism, lack of equal protection, denial of free speech, so on and so forth. Why that entrance of the problem into human rights is seen to advance the cause very seriously. Is there some latent power? There are no troops, as we know. Some connective tissue that develops among many countries because it's known, officially recognized as a human right? And does that connection stem from its relationship to another serious institution that has progressed since World War II, namely democracy? Does human rights get its strength from one or another form of relationship to democratic government? Does it become an imperative for democratic government? Does instituting an idea in human rights phraseology, through treaty, through declaration, through just broad discourse of many people in different cultures, does that advance it? Are democracies the root of transmission of that particular value, say racism? If not, why? What is the magic behind embedding ideas in human rights phraseology?
We'll need another panel for that.
That's what I was hoping for.
Okay, who wants to go first? Everyone's been invited through the questions. And this will be our closing as well.
So first to Henry, I will simply say, all tools. We need all tools. And human rights is, for some, the orientation toward normative thinking in international relations. For others, it's not, but we need all tools. To Thomas, I want to say, first, the disagreement between the ICJ and the treaty bodies may well impair the respect that is given by others to the treaty bodies. I don't think that it is going to impair the self-confidence of the treaty bodies to disagree with the International Court of Justice about the meanings of the treaties that they hold. Maybe in some cases it should shake their confidence, but I don't think that actually it will.
Thank you. 2 points. In relation to the reality of the function of special procedures, and I would say in general of the United Nations human rights architecture, there is, of course, tension that is important between the role of the High Commissioner as the leading voice of the UN in human rights, and then the role of the High Commissioner's office as the provider of support for special procedures, treaty bodies, and other processes. And I think this tension has been handled quite well up until now by High Commissioners who have insisted on certain firewalls with, for example, the function of special procedures. But it is true that at some point we do need to actually ask ourselves until which point are we going to pretend that it makes sense to have a system that actually functions the way that it does, with special rapporteurs and independent experts that are not dedicated full-time to their work, and in relation to which there are very, very perverse asymmetries created by the fact that skewing goes towards special rapporteurs and independent experts that have either independent wealth, and if you're not a French count having a vineyard, then you actually need to have a university that is somehow willing to create the model for you. And I think that that's where the tension lies right now, is that that's the point that we're reaching. The last point that I'd like to make in relation to this is very, very specific, is none of these structures have real structures of implementation or follow-up. That's true of the treaty bodies and it's true of the special procedures. And so it all comes together at the Office of the High Commissioner and the fact that this office has field presences and processes for follow-up. So the question is how to make the most out of that equation. Of course, Henry's point was extremely provoking for me in terms of just the richness of it. I think part of the difficulties that we face right now in the paradigms that we have been using for a long time is that it's easy now to actually understand that some of the specific, I would say, paradigms of democracy, rule of law, separation of power, that we safely thought we could rely on at the beginning of this golden era, as many people have mentioned, are now very clearly under scrutiny and under very clear erosion. Part of the work that I carried out that really puzzled me is how do you actually speak of the rule of law when there's proliferation of legislation that is actually not only criminalizing, but also prohibiting the work of organizations and outlawing the gathering of information, of data in relation to gender identity? How do you promote the idea that you're working only for good legislation that then you need to actually establish some parameters for? How do you work for access to justice when basically the work of courts is actually undermining human rights? And I think that this is part of the difficulties that we're working with in this democracy paradigm that I think we used to operate more safely, and that now I think we also need to question quite substantively.
Karima, maybe I can ask you to come in now.
Thank you very much for the question that was posed to me. And I should say first, I agree with everything that Victor said. And one of the things I was most grateful for when I was a special rapporteur was being able to cooperate and collaborate with excellent experts and rapporteurs like him, including when he served in the coordinating committee for the special procedures mandate holders. I'm very grateful also to the Office of the High Commissioner for Human Rights for so much work that enabled my own, but I will be very frank and say it's also a very complicated relationship, and I did face some real challenges to my independence from the Office of the High Commissioner for Human Rights, which I didn't expect. I expected those from states, but did not really foresee the number of ways in which at times the bureaucracy attempted to constrain my actually fulfilling my mandate. So there were times when I was being asked not to speak publicly about things when, in fact, the victim in a particular case wanted there to be public comment on his situation. There was a country communication, which I literally fought for a year to get out. And so I think in the future, and I address this to the friends of human rights, not the enemies of human rights, who of course use any suggestion you make as an excuse to weaken the system, but to the friends of human rights, I would say we need to think really creatively about the possibility of having a separate bureaucracy that supports the special procedures mandate holders and has the interests of those mandates as its primary focus. You have to imagine what it's like to work with staff who do not work for you, who take instructions from someone within the UN bureaucracy whose promotion depends on pleasing those people. And in my final report as Special Rapporteur, I said that the Friends of Human Rights need to explore ways that are in accordance with the Code of Conduct for Special Rapporteurs, ways to actually provide them directly with funding, because funding goes into the bureaucracy and sometimes it never actually ends up in the mandates which were supposed to receive it. And the last thing I'll say is, I said in my final report, it was a great privilege to be a special rapporteur, and it's amazing how much is done creatively through this system that has a real impact, but it is also like pushing a boulder uphill with a toothpick. And we have to do everything we can to have the strongest implement possible to push that boulder up the hill with. So thanks for the question.
Yeah, I would just underscore everything that's just been said about the special procedures, because I've heard that from many mandate holders, that this is a problem. I don't know if another bureaucracy would do it better, or if it's really just a question of discipline. I mean, I think that there are some clear principles that should be applied in these contexts, and the problem is there really isn't much of an enforcement mechanism or any kind of complaint mechanism that seems to be effective, although I've heard many complaints. But to address the question about funding for women's rights, and thank you for that question, I think that we have to really step back, and funders in particular have to start looking much more critically at the way in which they do their funding, and the way in which that can sometimes inadvertently but systematically exclude some of these actors who would potentially be able to do a lot more with a lot less of the funds. And I've seen many examples over the years. For example, in the Congo, an amazing woman in Goma doing a project to train women to run for political office attracted the attention of the State Department, and they invited her and urged her to submit a proposal. She spent a lot of time working on the proposal, and then they rejected it because it was in French, and she didn't have the capacity to translate it, and that was the end of that. And things like that that are just a bit thoughtless. Another government more recently with a really tremendous Afghan human rights activist who was forced to leave the country, started her own agency to document human rights, was very well regarded by everyone, and this government begged her to allow them to give her money. They wanted to give her $2 million. But then once she set up the NGO, they said she needed 3 years of audited financial reports, which of course she didn't have. And it just became her full-time job to try to get that money instead of document the human rights violations in Afghanistan, which was the purpose. So lots of little things like that. And then more systematically, I mean, if you see, the Canadian government made a very big commitment a number of years ago to really get money to frontline grassroots women's activists, because all of the major institutions, the World Bank, the UN, everybody has recognized that that's a smart thing to do for development, for peace and security, that it's a very good investment. But then they can't do it. And in Canada, they had a high percentage, and then you watched over the years, it went down and down and down. And when you really dig deep, you can see it's just too hard for them bureaucratically. These are small groups. They can't manage the kinds of bureaucratic requirements that are there. So it's an issue that I think really needs some further consideration if we want to really make our commitment meaningful, because the commitment has been made rhetorically again and again. And just lastly, I think we're all just so taken with this AI issue, and I'm finding myself just thinking a lot about it, and just, we used to say with business and human rights that corporations were just running circles around the UN because the UN couldn't keep up. The way the system was so cumbersome. And I feel like what you're saying is, AI is running circles around the human race, and we're just not aware, we're not keeping up on it, and it feels extremely urgent. So I hope we will continue to talk about that.
Martha, you want to pick that up? Bring us in?
I guess I would pick up on Henry's point, or very rich set of questions, and also the question about right to truth, and just make this comment that we are living in a time of war. Maybe there's always war, a time of just terrible conflict. The dream of human rights is part of the dream of using words instead of violence. And institutions are a way to make words have force. But institutions end up having lives of their own that don't serve the dream. And it is that paradox that the human rights program, I think, has always addressed. Jerry's comments about the critique is at the source of this program. It's a critique of the human rights establishment as well as the critique that requires human rights. And I think keeping attention to that paradox is central. I don't know what to say about democracy right now. Sorry, I just don't know if it's strong enough. But also I would be sorry if human rights only applied to democracies. And that you had to have a democracy to also have human rights. And I note that Larry Tribe has a quotation in the newest issue of the New York Review of Books that is about the US, but I think it could be very much about human rights as well, in which he says, but never forget that law can oppress as easily as it can liberate, and that it is the content and spirit of our laws and the character of those we entrust with enacting and enforcing them that makes fidelity to law so central. And I think that's why the language of rights matters. It inspires something about what is the human spirit, but if it's not informed by the human spirit, it's just words on a page or digital dots.
And with that, please join me in thanking this incredible panel.